Hello, and welcome to Crime in Court. My name is Heather, and this is another update in the Delphi case. So we are actually, I can't even believe we're here, but we are preparing for trial. We have the speedy day countdown. I'm not even sure where we're at right now. It's the May 13th. So today is April 30th, so we have about 13 days. Are there 30 or 31 days of April? I don't know. Anyways, so that's where we're at right now. There are 30. So we're 13 days away from trial. Okay, great. Good to know. So first of all, we're going to go over in this video the motions in limine that Nick McLeland, the prosecutor in this case, filed yesterday, and we're also going to go through first, the courthouse decorum from Judge Gull, which was just ordered yesterday. So let's go through that real quick, and then we'll go through the motion in limine from Nick, and please don't forget to hit that like button as we begin. Thank you so much. All right, and thank you just for being here. Your likes, your views, they're free, and they're very much appreciated. All right, so we have the courthouse management and decorum order for jury selection, which begins May 13th. So, like I said, coming up quick. This case has generated substantial public interest and media attention. In light of this, and on the court's own motion to ensure the integrity of the proceedings, to protect the defendant's constitutional rights for due process, to ensure the safety of the parties and the public, and to permit public access to criminal proceedings, the court sets forth the following rules and guidelines for jury selection May 13th through the 16th. So they're planning on 3 days of jury selection, I guess. I don't know. I don't know. They figure they're going to get it all in that time? Or what? I don't know. Usually, these high-profile cases take more than 3 days to get a jury, but it took Karen Reid over a week. Number 1, the courthouse will open at 8 a.m. All entrances are closed except for the entrance on the east side of the building. The remaining entrances will be locked with no access to the building. So is this the only trial that they have going on in this courthouse? It almost appears that way. Number 2, all members of the public, including members of the media, are subject to screening by metal detectors. All bags in possession of those entering the building are subject to search. That's pretty much standard in any courthouse. No weapons. Number 3, no weapons of any kind are permitted in the building except for on-duty law enforcement officers providing security to the courthouse and the parties. Number 4, no electronic devices, including electronic watches. So you can't bring your smartwatch into the courtroom with you. None are permitted in the building. Violations are subject to seizure and destruction of the electronic device without further notice. So you bring your smartwatch or your phone in there and they might destroy it if they want to, for whatever reason, because she can. Number 5, media personnel are permitted to attend the court session. No cameras, electronics, laptops, or recording equipment of any kind is permitted in the Allen County Courthouse. The court requests the media be mindful that other county offices are conducting business in the building unrelated to this case. Media and members of the public are ordered to conduct themselves in such a fashion as to limit disruption to the offices, personnel, and patrons of those offices. Number 6, the media are free to use the public areas outside the courthouse as long as they do not obstruct traffic in the streets and sidewalks surrounding the courthouse. So we have no cameras, no media is allowed in the courtroom, but no cameras. There's no recordings. And in a case such as this is a case where we absolutely need recordings. We need cameras. We need transparency in this case. It is completely bogus that the judge says no media. She just wants to protect her own interests. It's very annoying. A lot of her rulings have been very annoying. Number 7, public seating in the Allen Superior Courthouse. 1 is extremely limited. The sheriff of Carroll County or his designee will ensure that the victim representatives are seated and that the defendant's family is seated in 6 reserved seats in the back of the courtroom. Why the back? The credentialed media is allotted 5 seats to be divided at their discretion. So she's only allowing 5 seats to the media. That's ridiculous. This woman is outrageous. I'm outraged, as David Unetti would say in Karen Reid case. You should be outraged. We are outraged that this woman keeps denying press and cameras. So many people came forward and asked for her to allow cameras, and she denied without hearing. I guess it's her right, but I don't think that it should be. I don't think that judges should have any say as to whether a camera is or isn't allowed in the courtroom. I think it should be allowed in all cases. Every courtroom should have video recording so that the public, because it's supposed to be for the public, for all of us to see, should be on the internet. It's not that hard to do, people. Many courthouses are doing it. Why we're so behind, I don't know. But this is Judge Gull's wishes. All right, so the credentialed media are allowed 5 seats. The court will not mediate any dispute regarding seating. The remaining seating in the back of the courtroom, if any, is available until full. No one other than court security and law enforcement will be permitted to stand in the courtroom. So bailiffs can stand, courtroom security, law enforcement, but no standing room only. All right, so number 8, no food or beverages are permitted inside the courtroom. I couldn't have my coffee. Water will be permitted for the parties in the well of the courtroom. So I'm assuming that means I've never heard that term, in the well of the courtroom. I guess that means probably like the lawyers and the defendant, all the people that are players in the case. They're allowed water, but all the people in the back, you can't bring water or anything to drink. You can just be thirsty all day. Number 9, all members of the public and the media are required to follow directives of the Sheriff of Carroll County, the Sheriff of Allen County, courthouse security, and courtroom security. Number 10, no court-produced recording will be made available to the public or media. That right there is so important. Why? Why are we not allowing this to be public? It should be. The audio record made pursuant to Indiana Criminal Rule 5 may not be copied or used for purposes other than perpetrating the record. So, no court-produced recording will be made available to the public. So they are recording it, they're just not making it available. If I'm hearing that right, and it's only audio. I hate that judges have that much say. They shouldn't. They absolutely shouldn't decide, oh, you know what? The rest of society can't watch this because I'm afraid that they're going to see the corruption in my town or in my county. My dog is so annoying. She has to get under the blanket, but yet she stands on the blanket, so I can't pick it up for her to get under the blanket. And she always has to do this while I'm recording. And then she won't lay down. Thank you, finally. Okay, she's a princess. All right, so I'm sorry about that. At the conclusion of the scheduled session, all members of the public and media will remain seated in the courtroom until court security releases them. What? What is that about? At the conclusion of a scheduled session, all members of the public and media will remain seated until the court security releases them. I guess that's standard. So you don't leave until after the judge leaves, and I mean, you stand for the judge and then you wait for the bailiffs to let you out, I guess is pretty standard in any courtroom. So I guess that's not that surprising. Number 12, the courtroom will be locked between sessions of the court. Doors will be unlocked for the afternoon session at 1:45 p.m. The court anticipates that all members of the public and the media will conduct themselves in an appropriate fashion. Any violation of this order and any conduct the court finds disruptive of the proceedings is punishable as direct contempt of court and will result in a term of imprisonment and permanent exclusion from the courtroom, the courthouse, and all future proceedings. So if you get caught trying to record this, I'm sending you to prison. Is basically what she just said. So that is her courtroom decorum order. Let's move on now to the motion in limine. This is from Slick Nick, the prosecutor. Now comes the state of Indiana by prosecuting attorney Nicholas C. McLeland, and respectfully requests that the court enter an order required the defendant or his counsels to refrain from mentioning in the presence of the jury during voir dire, opening argument, presentation of evidence, and closing argument. So basically, at all. You cannot mention these things. Any and all references to the following, either directly or indirectly. This is what Nick wants. He wants to basically knock out the entire defense of the defense. Like their entire argument, their entire theory of the case, everything that they've been prepping for this whole time, he wants to eliminate that from their defense. Let's just read. Number 1, any comments about counsel for the state that constitutes a personal attack on the attorney for the state or comments on the role of the state's attorney. Don't make fun of me, please. Don't make fun of me. Don't say bad things about me, is what he's saying there. Number 2, any comment which constitutes the personal opinion of defense counsel about any evidence, witness, outcome, or penalty. For instance, defense counsel cannot vouch for the truthfulness or competency of any of the state's witnesses, including the police officers or any of his own witnesses. So, don't vouch for the truthfulness of what your person is testifying to or what my person's testifying to, because it's going to be cop versus cop. Cop theory versus cop theory, because we've got the whole unified command who is saying, don't look over here at this Odinist angle. It was definitely Richard Allen. And then you've got the other camp, the Ferenczi, Click, and Murphys of the world who, despite unified command's ignorance or basically ignoring the facts and not acting on it, these other 3 officers went and continued investigating that lead into the Odinist ties, and one ended up mysteriously being executed on the job. We don't know. Maybe he got too close. I don't know. We still don't know, really, what happened and what that's all about. I did do a video about it. There's no Odinist ties that I could find, but it's still very mysterious and tragic. Anyways, so yeah, they don't want the defense to say, well, our law enforcement is more trustworthy than your law enforcement during jury voir dire. This is jury selection, the jury selection process. They don't want the defense vouching for their witnesses or putting the state's witnesses down, which, I don't know, whatever. Okay, number 3, any innuendo or inference that is not supported by admissible evidence. Attorney cannot assert unsubstantiated allegations on collateral matters. Attorney may not comment or allude to inadmissible evidence during trial, but that's a given based on Indiana Professional Conduct Rule 3.4. I mean, they have to conduct themselves in a professional manner, and that's one of those things, is not talking about inadmissible evidence. And I have a feeling well, I'll leave it at that. It's all because Nick wants the Odinism stuff inadmissible. He wants their defense inadmissible, which is completely undermining and underhanded that he's doing this, because you're cutting their legs off at the knees. You're not giving them any option. Trial starts May 13th and you're trying to take away their defense. And the only reason you know the defense is because they've had to make it public in order to fight the powers that be. So it's unfortunate. This happened in Karen Reid case as well. There's a lot of parallels in Karen Reid in this case, I've noticed for a long time. But anyways, so in the Karen Reid case, they put out their theory ahead of time too, ahead of trial. And then of course the state's like, well, we want to stop that talk. We don't want any talk of your theory, which is that she was framed or there's a third party that did it. So they try to ban that. It didn't quite work in their favor, but technically they're still working on trying to prove that there's a third party, but we're only on day one, so. But their opening statement was pretty powerful compared to the state's. Anyways, so in this, they want no talk of certain topics, and we'll get there. Number 4, any attempt to indoctrinate the jury during voir dire process by exposing the jury to substantive issues in the case. So you can't talk about specific facts in the case. You can only talk about like things at a high level when you're doing jury voir dire. You're not supposed to be able to be really, really fact specific in the case. Or number 5, any attempt during voir dire to have the jury prejudge the credibility of a witness, which you're not supposed to do anyway. So I don't know why they're like pointing out things you're not supposed to be doing as an attorney regardless, but he wants it ordered by the judge. 6, any hypothetical questions that includes facts that are not in evidence or questions that are not helpful in violation of Rule 705. So you're not allowed to ask hypothetical questions, I guess, if it includes facts, but facts that are not in evidence. Or questions that are not helpful. Well, who determines what's helpful and what's not helpful? That's stupid. 7, any attempt to introduce evidence of third-party motive, here we go, that is not relevant and or the probative value is outweighed by unfair prejudice, confusion of the issues, or has the potential to mislead the jury in violation of Rule 401. Before any such evidence may be permitted, the defense must show some connection between the third party and the crime. And that's good practice. You don't want defense attorneys just slinging out, accusations at other people with nothing to back it up. But at the same time, if you've read the Franks memorandum with me, which, I read it on my channel in 9 parts because it's a very long document. If you read it, they lay out third-party motive. They lay out third-party culpability of others. Lots and lots of reasonable doubt and pointing the finger at other individuals that could have done this. So, in my mind, I think they should be allowed. There's been so much that has come out that has... that you can tell that the state is quite upset about that it's even out, like the Franks memo. Even Judge Gull, she hates that memo. You can just tell. You can tell by the way that she, removed them from the case immediately after that came out. So it's pretty evident that Judge Gull and Nick want nothing to do with this Odinist stuff. So here we go. Further, it must be a direct connection based on admissible evidence and not founded in hearsay, speculation, rumors, conjecture, or theory. So they're trying to get their theory tossed out. That's what I'm thinking. The state requests such order in limine to include, but not be limited to, the following. So these are all things that the state does not want the defense to mention at all. Throughout their opening, throughout jury selection, throughout the evidence portion of the trial, throughout their closings, nothing. Nada. And this is their defense. So, look, state requests this, all of these things to be excluded. Odinism, any talk about Odinism, cult or ritualistic killing. Brad Holder, Patrick Westfall, Johnny Messer, Elvis Fields, Ned Smith, Rod Abrams, Keegan Kline, Jerry Klein, Ron Logan. Those are all individuals that may or may not have some ties to this and in an Odinist cult or ritualistic killing kind of way. So all of those people should be included, but we shall see what Judge Gull says. I'm not really hoping, or I'm hoping for something less strict than what Nick is asking for, but I don't know. She might just be like, okay, so ordered without hearing, you know. That's so scary. It is so scary that she has that much power. And people don't understand, like, all this stuff in the beginning of the trial, all this pre-trial, these motions and things. This is where you get to keep evidence out or include certain evidence by doing these motions in limine and, you know, all these pre-trial hearings to get rulings before the trial starts. So all of this is so important because it leads us to the trial. The defense might not have anything. They might not be able to present their theory. If she approves this is insane. This is insane. If she approves this, she is totally off the rails, I swear. Like, I already think she is, but I think we all need to come together, protest, get her off the bench. She needs to go. I'm not in Indiana, but I think anybody in Indiana who's there in Allen County should be protesting her every single day until she recuses herself from this case, and she's not going to, but anyways. So, number 8, any reference to an investigation conducted by Todd Click. So, yeah, they don't even want this. Any investigation conducted by Todd Click, along with any reports or investigative materials from Todd Click that is not relevant or is used for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is not on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses the issues. So he's saying anything from Todd Click or this other investigation about the Odinists, it's just going to confuse people, Judge, so let's just leave it out. That's so ridiculous. All right, so number 9, any reference to geofencing and or any testimony from Kevin Horan about geofencing or the findings from any geofence search that is not relevant or is for the purpose of confusing the issues or has the potential to mislead the jury in violation of Rule 401. Burden is on the opponent to show why it is relevant. Relevant evidence may be excluded if its probative value is substantially outweighed by the prejudicial effect. Evidence may be excluded if it confuses the issues. Again, he's saying get rid of it. Nothing is going to be, all this stuff about Todd Click, this geofencing, which proves that Richard Allen wasn't there at the times where the state's theory says that the girls were unalived. However, there were cell phones in and around that area all throughout that afternoon, and they either would have seen something or were the suspects, those individual phones in the geofencing area at that time. So to keep that out is excluding the defense's right to poke holes in the defense, or I'm sorry, in the investigation, and the fact that there were other angles that they should have investigated but didn't. And it's exculpatory. Number 9, any reference to geofencing and or any testimony. Oh, I said that already, sorry. We just read that. Number 10, any reference to any prior bad acts or acts of any witnesses that plan to testify at the trial. So we don't want bad acts of our witnesses. So if our witness has a criminal record, you can't bring it up? No, that's not how it goes. Like, you're supposed to be able to question their reliability and their credibility. And if someone has bad acts and it's relevant, they should be able to bring it in. All right, so anyone who has prior bad acts or acts of any witnesses that plan to testify at the trial that is not relevant to what the defendant is on trial for, that is not an act that is an exception to IRE 404B, and that is not both relevant under 401 and tend to negate the guilt of the defendant. So, can't bring in any exculpatory evidence. All right, number 11, sorry. Number 11, any reference to how the files were labeled that were any reference to how the files were labeled that were handed over to the defense as part of the information and discovery provided to defense counsel by the state that are not relevant or that would tend to cause confusion of the issues or has the potential to mislead the jury in violation of Rule 401. So anything that the state provided to the defense in the way that we provided you the information and all the discovery, you can't mention the fact that we buried all the Odin stuff way deep in titles that had nothing to do with anything. And we made you search like for a needle in a haystack. I couldn't think of the word. We made you search for a needle in a haystack in all the discovery because we didn't label anything appropriately when it came to the Odinist stuff. So, yeah, but you're not supposed to mention that. Don't tell anybody. Don't talk about that in trial either. So relevant evidence may be excluded if its probative value substantially outweighed by its prejudicial effect. Evidence may be excluded if it confuses issues. He keeps repeating those things because that's all he has. Number 12, any reference to any PowerPoints provided by the state as executive briefs involving any person or persons that were investigated by law enforcement as part of the 6-year investigation into the unalivings of Abigail Williams and Liberty German that are not relevant or would tend to cause confusion of the issues or has the potential to mislead the jury. Any reference to any PowerPoints, this was a really long sentence. So the state provided PowerPoints at some point, which had by the state as executive briefs. So they were, the defense received in its discovery something called executive briefs, I'm taking, which are PowerPoints that show who in law enforcement was investigated within the 6-year investigation. All of the people, all of the persons and whatevers that were investigated, that was handed over in PowerPoints, and you can't use them, apparently. The burden is on the opponent to show why it's relevant. Same old thing. We're not going to read that again. All right, so wherefore the state of Indiana, by prosecuting attorney Nicholas C. McLeland, respectfully requests this court to grant the following relief. A. Order the defendant through his counsel and witnesses to refrain from mentioning, commenting, or making any reference whatsoever, either directly or indirectly, to any of the above matters without first obtaining permission of the court outside the presence of the jury, or outside the presence and hearing of the jury. So I guess they can still bring it in if they do like a proffer or something, perhaps. I don't know. And letter B, to further order said persons to make no reference to the facts that this motion has been filed and granted, and all other relief just and proper in the premises. So you can't tell them, we prevented you from talking about these things. So you can't say, oh yeah, there was this whole other theory that we had, but we can't talk about it because the state blocked us from talking about it because they're evil. Nick McLeland and Judge Gull are evil. Pretty much. If she grants this, oh my God, heads should roll. She should not be on this case. She needs to recuse herself. Nick should have recused himself long ago. These people, Nick doesn't know what he's doing. He's in way over his head. And I can't believe it's gotten this far. But then again, I've been watching the Karen Reid case and we're on trial day 2 today. So I don't know. Anyways, I'm going to leave it at that. My final thought is really, I'm very fearful for Richard Allen and for other individuals in Carroll County, in Indiana, in that area, in Delphi. I'm very worried for Rick. I'm worried that Judge Gull is going to block him from having his entire defense theory just wiped out in one foul swoop. She'll just, nope, you can't talk about this. And I guarantee Nick McLeland and Judge Gull are talking about this kind of thing. Like, he's getting direction from her, because I don't think he's smart enough to come up with this on his own. I think he's getting direction from Judge Gull or somebody else saying, you need to do this. You need to do a motion in limine to exclude all Odinism stuff. And by the way, Judge Gull's just going to approve it regardless of anything. And she's not even going to ask for a hearing. So you can ask for whatever you want. She'll just say yes. That's kind of what I'm thinking is going on behind closed doors. It would be highly illegal, unconstitutional, unethical, immoral, but I already think that the state in Carroll County, the representatives in Carroll County already are those things. So, like I said, I'm just scared for Richard Allen and him going in with a fair shot. I don't think he's going to get one, unfortunately. And that is where I'm going to leave you. Hopefully I'm wrong. I really, really hope she's going to be like, no, I can't block him from his entire defense. But I don't see that happening. Anyways, I'll leave you with that. Hope you guys are having a great week. We are on Tuesday, April 30th, last day of the month. We're about to be in May, and we're in spring. So, the weather's starting to pick up here in our cold climate in Chicago and other, northern cities. So at least we have that going for us. So like I said, May 1st is tomorrow, and then this trial is going to be just a short little skip away. So hopefully we get more information than just people who were there and providing us their knowledge, but I don't think she's going to give us cameras either. So, all right. Well, thank you guys so much for watching. I appreciate you. Please hit the like button on the way out, and I will see you in the next one. Take care, guys. Bye now. If you've been impacted by a true crime and would like your story told in your own words, or if you or someone you know has been wrongfully convicted or accused of a crime, please write to crimeincourtchannel@gmail.com and tell us your real true crime encounters. Thanks for watching.